accused number one's lawyer, Thulani Mngomezulu, has told the Senzo Meyiwa murder trial that he believes Ntuli-Kelly Khumalo and accused number 5, Fisokuhle Ntuli's rights to privacy were violated. This is when police extradited records allegedly showing calls between the two. The former police data analyst, Lambertus Steyn, facing cross-examination today after being recalled to clarify discrepancies between his prior testimony and that of Vodacome expert. The 5 men are on trial for the footballer's 2014 murder. Newzroom Africa's Mnisi reports.
A tussle over whether calls were made between footballer Senzo Meyiwa's then-girlfriend and one of his alleged killers. The state claims Ntuli-Kelly Khumalo and accused number 5, Fisokuhle Ntuli, communicated twice before the shooting at the Phosphorus house, which led to the former Orlando Pirates and Bafana Bafana skipper's death. But accused number 1's lawyer is now claiming that the cell phone data was unlawfully obtained.
This is what I'm going to argue at a later stage, that they infringe the rights of these persons in terms of Section 35(5).
Which rights are those? Sorry, let me understand. Which rights are those?
That the information obtained from Kelly Khumalo or the communications relating to what the state is alleging, it was a communication between Kelly Khumalo and accused number 5 was obtained unlawfully in terms of Section 35(5).
I thought number 5 is saying never communicated with Ms. Kelly Khumalo.
That's correct.
Now, how is that reconcilable?
My Lord, may I address it?
Yeah, fine.
For the court to understand. I said this is what the state is saying. This is not what I'm saying. Okay. Accused number 5 has said. I'll argue from the point of what is said by the state.
Steyn on Monday told the court that Vodacome's records were based on direct calls, which do not reflect those made using internet data. He further revealed that 2 hours needed to be added to the time of the calls, changing the ones he had initially presented in court. But accused number 3's lawyer believes Steyn had ample time to realize this mistake, even during his testimony last year.
But let me tell you, sir, that indeed you had more than 5 occasions where you could have effected the corrections or the amendment on what you are now saying, something that you forget to include in the document.
No, I still can't agree. Because I did complete the statement and the statement was spark.
Thank you.
I didn't read it every day. 2 years later, I come and testify.
The state also claims Khumalo's phone was rebooted hours after the crime in an attempt to wipe out information. Accused 2's lawyer says the artist's phone would have already been with the police at the time.
And you put the time of the device boot up at around 1 a.m. if I'm not mistaken. And by then, according to the testimony of Zandile, because they returned from the hospital between 11 and 12 a.m., 11 p.m., 12 a.m., 00 a.m., the phone was already in the possession of the police. So the user or the owner could not have been the person that performed that device boot up action or activity on the phone.
My Lord, I can't testify on when did they seize the phone.
Cross-examination of the data analyst continues on Wednesday. For Newzroom Africa on Channel 405, I'm Mnisi.